In the complex landscape where innovation intersects with legal battles, there exists an entity known as a non-practicing entity, or IP, more commonly referred to as the patent troll. These entities accumulate patents not with the intent to innovate, but rather to exploit legal loopholes for financial gain, often through aggressive litigation over alleged patent infringements. Patent litigation filed by APs accounted for approximately 60% of all patent litigation up to 2020. Imagine a scenario where companies, noted as target firms, find themselves involved in litigation initiated by MPs. When MPs file for infringement of the patents they own and initiate patent litigations against target firms, these target firms could run the risk of being held up and incurring associated costs after investing in and developing the technologies patented by the MPs. The hold-up problem occurs when one party has made specific investments in a transaction and thus becomes vulnerable to be expropriated by the other party. A key insight derived from the theory is that conventional market contracts are insufficient in providing adequate protection against expropriation when investments are made in specific assets. Therefore, after the first litigation by the MP, it could become difficult, risky, or no longer feasible for the firms targeted by MP to practice or patent aggressively in the areas of MP litigation because the MP has already owned and claimed many of the patents in those areas, creating hold-up problems. To avoid future hold-up problems in the face of the rising threat and potential future litigations by the MPs, we argue that a logical and plausible response for target firms to avoid the risk of hold-up in these specific areas is to turn to a more inward innovation strategy to protect themselves from MPs after the initial MP litigation. This would allow the target firms to substantially reduce the risks of being targeted by MPs again and incurring further direct and indirect patent litigation costs. In this paper, we find that after the initial MP lawsuit, these target firms use their in-house technologies more to reduce the legal ground for future lawsuits and avoid the hold-up problem resulted from these MPs. Using backward self-citations of patents as the measure of inward innovation, we find that after the MP lawsuit, the target firms increase backward self-citations by 17.6% relative to the sample mean. Moreover, non-target firms in related technology areas move their innovation activities away from those of target firms to avoid the areas with high IP litigation risks. In other words, these non-target firms distance themselves from the existing innovation activities at risk of IP litigation in an attempt to escape the patent trolls. This study sheds light on the impact of patent infringement lawsuits initiated by MPs on firm innovation strategies and inter-firm innovation activities. Our paper shows that MP litigations could interrupt the accumulation and buildup of follow-on technology, which disrupts technological development in the industry. Indeed, decision-makers and managers in firms should be cognizant of the impact of MP litigations and how anti-patent troll laws can potentially help enhance collaborative activities among firms and facilitate the systematic development of valuable technologies by allowing firms to build on one another's patented technologies. This study also yields important policy implications, where our paper provides the theoretical and empirical support for governments to engage in anti-patent troll regulations, such as America Invents Act and anti-patent troll law in the United States.